Hello everybody, and welcome to, I guess, our next to the last lecture in Psych and Law. We're going to talk about punishing and sentencing. So you notice as we move through the course, we kind of, started at the beginning of the judicial system and kind of finishing up at the end. And that would be where punishment and sentencing takes place. So let us begin then. First we can describe types of sentences. Determinate sentencing, right? A sentence is fixed by statutes and sentencing guidelines. And the sentence is essentially determined by legislators and prosecutors. And if we go back to our conversation of Dr. Walker and the idea of discretion within the legal system, and as that touches on what our third dilemma, equality versus discretion, we see that determinate sentencing works to take the discretion away from people, from the judges. So legislatures responding to public opinion, at least maybe hopefully, right? Prosecutors get together and they determine sentences for various crimes, and it sets guidelines and or requirements for judges to sentence. This then contributes to the hidden power of prosecutors because based on the charge that they decide to bring or the charges they decide to bring, they already have a pretty clear picture of the sentences that would be meted out given a conviction. Now, intermediate sanctions are tailored punishment to fit the crime, and these are often used with nonviolent crimes. So it might include restitution, community service, some form that is tailored to fit the nature of the crime more specifically than just these kind of blanket rules that are generated in determinate sentencing. Psychologists are often key in determination of punishment in these lower level cases. And then mixed sentencing generally presents itself with mandatory minimums, right, and then on up to maximum. So in this case, a judge has to give a sentence upon guilt, has to make the sentence, but they are somewhat flexible in that they can give the minimum sentence or move up from there. When I first arrived at Ohio State in the social psych department and working in the Tetlock lab, we were looking at how people decide to punish norm violators, rule violators, if you will. And we did a lot of studies where we presented participants with crime stories of various types and then queried them on various aspects of their punishment decision. The basics are like, is this person guilty or not guilty? From there, if they're guilty, how long should they be sentenced? We might ask more nuanced questions like, to what extent do you believe that the criminal could have foreseen the consequences of their crime? So we often looked at foreseeability as an issue. We looked at various excuses. To what extent should a person not be held responsible based on some context or circumstance? This was kind of the nature. But we also looked at our research participants. And one of the areas that we were especially interested in was to look at, in fact, the reason that they're handing out this punishment. What motivated you to punish in this manner or to this extent. And through this research, doing it over a long period of time with a huge number of participants, then we can kind of categorize their responses into the goals that were driving their punishment. So the punishment motivations, if you will, motivations or the goals of the punishment. And the one that came clear very, very clearly and very often was retribution. And this is, you know, kind of the biblical reference, if you will, an eye for an eye, a tooth for a tooth. That is to make the person engage in retribution for their crime. Now, sometimes we saw punishment that were motivated by moral outrage, that is, this crime offends our morality. It causes us to become angry, so out of our moral outrage causes us or motivates us to punish, right? Now, general deterrence is an interesting concept that's really kind of at the core of legal systems throughout the world. The idea is that by punishing an actor, and notice in our court system is supposed to be open, so trials are held in public, and then the announcement of the verdict is held in public, and then finally the sentencing is done in public. then the freedom of the press kicks in and the press reports on the verdict and the sentence. And the idea is here that when we punish someone, yes, we're punishing that person, but we're also sending a message to others that if you do this crime, then you can expect a similar punishment. So, and I remember I asked a question in class, what about robbing a bank? Has anyone considered robbing a bank? And we think, well, we don't rob banks, why don't we rob banks? Not because we've ever personally experienced the punishment for robbing a bank. We watched others who have been punished for robbing a bank and say, oh my God, I don't want that punishment, so I'm not going to rob a bank. And so the trial process, if we look at Miller and Bolster, if it's a meaning-creating device and sets boundaries on life, it says if you commit these crimes, then in fact you will be punished. So this communication deters us in general from committing crimes. Now, you can compare that to individual deterrence, and this is when we attempt to deter the individual who've committed the crime. So by punishing someone, and this is something we might do with a child, right, who is reaching for something that they're not supposed to touch, and we slap them on the hand, then we're attempting to individually deter that child from engaging in that action now and in the future. So we have 4 under our belts now. Incapacitation. This idea is often applied to people who are so scary or so evil or so threatening that we want to put them out of commission, so to speak. That is, we want to make sure that they're never able to commit this type of crime again. That is, we incapacitate them, we lock them up and throw away the key, might be the cliche that's used there. Now, rehabilitation is purported to be one of the cornerstones of our jurisprudence system. That is, we punish people. Punishment is one aspect of it, but what we really want to do, our ultimate goal, is to rehabilitate them so they don't commit crimes in the future by putting them on the straight and narrow, teaching them the correct way to live or behave, right? And the prisons are set up as facilities that participate in this rehabilitative process. To the extent that that's realized as controversial, rehabilitation, while it's usually strongly desired, in practice doesn't occur as much as we probably want it to. And then restitution. So when we talk restitution, it's paying for the crime, that is making good on it. So if I broke someone's arm, then I should pay, in fact, their medical bills for that broken arm, right? That I'm somehow compelled to pay for what I've done. Now, that's the 7 goals that we observed, but which do you think was probably the most common? That is, we can ask which goal is typical goal of punishment for the average person. And when I say average person, we did this research with Ohio State undergraduates, specifically freshmen and sophomores, who are largely comprise the participant pool at Ohio State. And I'm going to call Ohio State as representative as the average person nationwide. When you talk about America, I think Ohio kind of sits strangely in the center of America, maybe not quite geographically, but I think socially and politically it's probably representative of middle road America. And what do you think the average goal then, what do you think the goal is of the average person, of the 7 that we just discussed? Well, if you said retribution, you're correct. And by and large, this is what we found Ohio State students were doing. This is the motivation they expressed for punishment, was to, in fact, have the person pay retribution. So here are some of the questions we asked to get at these. And basically, someone is exposed to a crime story in our paradigm, and then we determine guilt or innocence. The participant is given the opportunity to say they're guilty or not guilty, and then if they're guilty, what would be an appropriate punishment? We might ask other questions. And we usually had an array of 6 or 7 questions, and then it was the participant's strongest endorsement of one of these questions that allows us to label their motive. Now, these are going to sound a little weird because I pulled these directly from research we did. This was a huge study we did. We had literally probably a couple thousand participants in this study, but it was a big study. It was a 2 by 2 by 3 by 2 design, so there was 24 experimental conditions. We ran about 740 participants at Ohio State, That was actually my first quarter here as a graduate student in the Tetlock lab. And then, but also we were going to compare how people think in an individualistic society in the United States to a collectivist society, and we had a collaborator, Ramador Singh, who was operating the same study in Singapore. So, but the process then when you do that is we sent all our experimental materials before we started using them to Ramadar, and then they would be translated and then into language there, and then it comes to us back translated, so that we are using really kind of dependent measures that are equivalent between the two cultures, as equivalent as possible. So sometimes there's kind of some language peculiarities through the translate and back translate process. So, but let's take a look at them, and here's some of the questions we ask. So, to what extent do you endorse, and this would be on a 9-point scale we were using in this particular study, specific deterrence? Make sure JL never does anything like this again. JL being the character in this story who was guilty of drunk driving, and we manipulated it either to be a minor fender bender accident that he was involved in as a result of his drunk driving, or the death of a mother and a child in the car accident. Remember, we always manipulated the severity of the outcome as part of our research. So specific deterrence, or if you will, individual deterrence. Make sure JL never does anything like this. So to what extent did a participant endorse this, right? How important was it to the participant? The question to determine general deterrence level of motive was make sure other people get the message that JL's behavior is unacceptable to society. Okay, and you can see that's the general nature. To assess retribution, make JL experience some of the suffering he has inflicted on others by his deeds. So he makes others suffer, he needs to suffer. That's a strict eye for an eye, tooth for a tooth kind of a manipulation there that demonstrates retribution. Reintegration into community by humbling, and you might call this rehabilitation, although this is a very Singaporean and collectivist kind of version of this. Send the message to JL that he must live by the same rules as all of us, that he is not so special. And you can see where the translation becomes interesting there, but it reflects the cultural differences. Rehabilitation, to help reshape JL's values and personality so that he can function effectively in society. So you can see that within a Singaporean context, these two are easily differentiated. For Americans, maybe a little less so in an individualistic society. And here's another one: to affirm the values society places on the lives and self-respect of innocent victims of the crime. So this is a larger kind of collectivist goal, got very little endorsement in the United States. And then the restitution was handled by this question: to compel JL to compensate his victims for the harm he inflicted upon them, and this is straight up pay for the damages. So, additionally, moral outrage had a strong role too, because remember we listed that as a 7, as one of the 7 in the initial slide there. So we assessed participants' emotional reaction to the crime and the defendant to the extent that they were morally outraged. And this translates loosely to the notion of anger. And what we found in our research, that the level of participant anger almost always predicts the amount of punishment assigned to the defendant. So in any study where we ask someone's emotional response to what they read, and then look at their punishment preference, and then do the correlation, what we find is a strong correlation between anger and the amount of punishment given. In addition, in doing mediational analysis, once we look and we enter into the equation anger as a mediator, if you remove anger, then the effect goes away. So anger was one of the key elements in predicting the punishment. Now notice we didn't say anything about incapacitation there, and my partner in crime, or writing crime stories and evaluating the results, Derek Rucker, we haven't given up on incapacitation, and this goes back to this idea that specifically we hypothesized that anger would lead to the retributive type of punishment. Anger equals retribution. It functions through moral outrage quite often, but we said, and you know, I'm also an emotion researcher, so this appealed to me. It was the idea that if anger equals retribution, fear might yield a motivation to incapacitate. That is, to lock someone up. You know, retribution, I might take some heinous criminal, right, and put them out on the side of the highway picking up litter, or better yet, the old cliche punishment of hard labor. So we have someone out there with a sledgehammer all day long busting rocks, right? And this is something I would do to punish someone, to make someone suffer, to assuage my anger. But fear, on the other hand, is these people are so damn scary that I don't even want to take a chance putting them out on the rock pile. I don't want them communicating with other people. And maybe an example here would be Charles Manson, who seems to have these supernatural powers to influence others. And it's like, I don't want this guy out talking to anyone. I want to stick him in a hole somewhere, lock him in a cage where he can't contact or communicate with anyone. And this led us down a path to try and differentiate these two different types of punishment, and we never successfully did so. The short answer, which is actually a long answer if you take Psych of Emotion with me, is it appears that once you make someone afraid in the laboratory through whatever manipulations you use to make them afraid, and we did a lot of priming studies, both conscious and non-conscious priming, we could never differentiate fear and anger. And I hypothesized, and it still remains as a hypothesis, that when you scare someone, as soon as the initial fear wears off, right, it's supplanted by anger. How dare you scare me? That pisses me off. So the only thing we could really determine in the lab in this context was the effects of anger and not the effects of fear. So, and that's a big aside there. Let's talk a little bit about bias in sentencing, some overall kind of effects that are observed. Women at first glance seem to receive lighter sentences and more suspended sentences than men do. But correlation, of course, doesn't equal causation. I don't think we've said that yet in this course, so we better get it out there, because you have to say it in every course where you reference statistics, right? Just to reinforce the cliche. Women are less likely to have previous criminal records, so the sentencing is probably reduced in that regard. They're more likely to commit nonviolent rather than violent crimes, so it's a difficult comparison to make, kind of the apple and oranges comparison, when you're comparing sentencing of men versus women. But it would appear that this effect exists. Now, non-whites, offenders with black victims, get lighter sentences than those with white victims. Notice when I said non-whites, was it kind of tricking you? Oh, okay, so white people are going to get sentenced less than black people, but often what we find is kind of a little more nuanced than that, that it's the victim's color that maybe matters in sentencing to a greater extent than the perpetrator's color, and more on that later. So, Georgia study, black men, though, are twice as likely to be incarcerated for a similar crime than white men. So that would be on not the victim, but on the perpetrator. Now, let's talk a little bit about sexual offenders and what we call the special case of sexual offenders. The special case is because sexual offenders are perceived to be recidivists, that is, repeat offenders. That sex crimes are, considered rightly or wrongly to be motivated by deeper factors, and these desires, these tastes, these motivations, right, stick with a person. It's not something they can necessarily turn off and on. So when we see a sexual offender, we think less in terms of rehabilitation, we think more in terms of incapacitation, usually, to protect children, to protect women. So it's often a paternalistically motivated punishment to protect victims in some way or another. So, 3 goals of sex offender laws. The first goal, then, these special sex offender laws, is to protect the community when released through notification and registration. And we see that we often receive these postcards in the mail. Hey, you got a new neighbor, and let's tell you about them. And you go, oh, that's really freaking awesome. Many jurisdictions require people to register and notify law enforcement when they move, and it actually then constitutes a violation to fail to do so. Now, Megan's Law kind of set this up, decades ago now, a 3-tier system of notification. So low risk, moderate risk, and high risk will then require different levels of notification. And so who is notified depends on the level of risk. We get postcards, and that's usually moderate level offenders. When we're talking high risk offenders, at least in some jurisdictions, the police actually have to go door to door throughout the neighborhood. Yeah. So the critics will argue that released killers get less scrutiny. So if I commit murder, right, and then I'm released from prison having served my time and move back into a neighborhood, there's no notification process for someone who murders rather than someone who sexually offends. So critics might argue that, you know, murder almost seems like a worse crime, and yet the notification process doesn't kick in. And this is where I think we get to the idea that recidivists, sexual offenders are recidivists, so it requires this notification because they are likely to do it again. At that point, I gotta shut us off for just a second, and we'll go to part 2. So we're going to come back and look at the special case of sex offenders and goal number 2, goal number 3, and more on our conversation there.